I say next question.
We get your reaction to the verdict today. Just tell us what you think of what the jury decided.
I'll defer to my counsel.
Jay Carney and I showed up in June after looking at this case and working on it for some time, and we thought we were going to expose a little bit of government corruption. Little did we think that the government would expose more corruption than we ever could have. During that time, from the bottom all the way to the top, you saw the government bring out witnesses that had deals, life, money. And so at some point, hopefully this case is the beginning where people reflect a little bit on our government, ask our government questions about what happened and why it's still going on today.
Jim Bulger was very pleased at how the trial went, and even pleased by the outcome. I don't think he expected that 9 times the jury would come back and say not guilty or not proven. It was important to him that the government corruption be exposed, and important to him that people see firsthand the deals that the government was able to make with certain people. With that as what he was looking for from a trial, he's very pleased.
Did he call it a sham? Did he call it a sham? How could he be pleased with the trial and he calls it a sham?
He has a strong feeling that he should have been able to present his defense, but presenting his immunity defense was only one of his goals in this trial. It's rare that you can achieve all of your goals, and so the fact that he was able to highlight the corruption that he was in the middle of, as well as the corrupt, obscene deals made with certain witnesses, should be something that informs all the citizens about what happens behind the scenes in a federal prosecution.
There was no finding in the killing of Deborah Davis, no finding. What do you conclude from that? If Bulger didn't kill Deborah Davis, or if there's no finding in that regard, what do you think happened?
Hank?
Jay Carney and I were very pleased at the diligence of the jury, how they paid such attention throughout the trial, even some of the parts of the trial that were difficult and sometimes even boring. The amount of time they spent reflecting and deliberation shows that this jury was the best group of people to ultimately make the decision regarding the verdict. The government pinned their hopes on these predicate offenses, in many cases, upon witnesses who we thought had an absolute lack of credibility, an extraordinary motive to lie, and were not guides that a reasonable person could follow to help find a conviction. To ask a public or a jury to trust in whole witnesses that had such promises and inducements and such motives to lie, in some ways that's reflected itself in the verdict.
I'm pleased to be a criminal defense lawyer, and I'm proud of what Hank Brennan and I did in this trial, what criminal defense lawyers do every single day in this court and in the state courts. We defend people against criminal charges, and we do the best we can. There were a lot of sacrifices made by the trial team, a lot of sacrifices made by Hank's family and my family that allowed us to represent James Bulger in this trial. But for us, we feel that when we were appointed to this case, that we would do the best possible job we did, and the best possible job we could, and we feel that we did so. And we hope we made our fellow criminal defense lawyers proud, because they would have done the same thing we did.
Jay, do you think the idea that Whitey was not a rat, do you think that has been received by the jury? How do you think that idea has been received? Not an informant.
It's too bad we can't hear from the jury whether they think the government proved that Jim Bulger was an informant. We feel that with all of the evidence that we presented, especially from people who formerly were FBI agents and were agents of great integrity, that we showed that the myth that James Bulger was an informant was just that, a myth without any basis, without any substance.
Who was on trial for being an informant? Why was that so important to you?
It was important to us to show that he was not an informant, because if he weren't an informant, it undercut the credibility of every witness who said he was. And that's why it was equally important for us to present that at the trial.
Did the judge make an error when she didn't allow you to present the defense or the defense that Mr. Bulger had been granted immunity by a federal prosecutor? And is that grounds for an appeal now?
James Bulger has wanted to tell his story from the moment he was arrested. In this trial, while it tells quite a bit about the criminal justice system and the corruptness in the Department of Justice, it doesn't begin to tell the whole story. I don't think you've heard the last word from James Bulger. The depth of the corruption within the Department of Justice in that time, all the way to the top, is a story that should and hopefully still will be told. And so while there is a limitation in this trial on the relationship that James Bulger had with the Department of Justice, that doesn't mean it didn't happen. And so hopefully the public will have questions.
And with the appeal,
I'll defer on that question.
He does intend to take an appeal. Yes. He, James Bulger, intends to take an appeal.
You expressed frustration with the gag order throughout this case, and to a certain extent you expressed frustration with the way it was being portrayed in the media. Can you comment on how you felt that portrayal may have in some way shaped or hindered the case?
I think the local rule that prevents contact with the media and others once a trial begins is overly restrictive. That's particularly true in the federal court, where there aren't cameras in the courtroom. I wish that every citizen who wanted to would have been able to watch this trial on television or on an iPad or on a laptop. They would have seen things that would educate them about the federal government, that would amaze them, shock them, appall them, and just make them realize there has to be changes. When the cameras can't be in the courtroom, then it's incumbent upon lawyers to be able to come in front of the courthouse and speak on behalf of their client. It's very frustrating, and I hope that the rule will be changed.
Jay, if you could draw a lesson about informants, what might that be? What some informants are doing?
I think the use of informants is a dangerous practice. The government will offer people, in essence, bribes, not by money, but by something more valuable, freedom. And if they offer enough freedom to certain witnesses, I guarantee they will say anything, whether it's the truth or not the truth.
Mr. Carney, clarify, was it a given man who was an island, and was it your client's intent that you get that ring?
The criminal forfeiture laws allow the government to seize items that were obtained or maintained by illegal proceeds. Pure gifts to the defendant, as this ring was, are not forfeitable by a criminal forfeiture action. So the government didn't even pursue it.
How can a man who facilitated and benefited from public corruption his whole lifetime now be glad to see
I think at the end of a person's life, when people think he is the only bad person in the courtroom, it's important to show that that's not true, and that he was allowed to be the leader of the organized crime in Boston for 25 years, because law enforcement was corrupt. At this point in his life, he'd prefer to have the truth come out rather than just rely on a myth.
So why not testify to that? If his other goal was to expose government corruption, and one way to do it was to testify and tell all, why not do that?
He didn't testify because the judge, at the insistence of the prosecutors, would not allow him to present his defense. If you're charged with a criminal act and you have a defense, such as that you acted in shooting someone because you were acting in self-defense, and a judge says to you, you can say you shot the person, but you cannot say you did it in self-defense and you didn't think the person was you thought the person was actually going to kill you if you didn't kill him, and you can't say you were in fear and that's why you acted. All you can say is you shot him. What defendant in his right mind would take the stand in that kind of trial? Well, that's the situation Jim felt he was in, and that's why he did not take the stand. Had that ruling been different, this trial might still be going because he had a lot to say. I'm not at liberty to say because at this time it's under seal. Because it's important for the next person coming down the line, if he has or she has an immunity defense, that the Court of Appeals state with certainty he or she can present that defense to jurors. Mr. Bulger knew as soon as he was arrested that he was going to die behind the walls of a prison or on a gurney getting injected with a chemical that would kill him. This trial has never been about Jim Bulger being set free and coming out of this courthouse. I want to also comment on the fact that we're taking an appeal. This was an extraordinarily difficult trial for a number of people, including Judge Casper. I think she did an excellent job overseeing this trial. And I say that not because she's young or new to the bench. I don't put any qualifier on it. Judge Casper did an outstanding job facing the challenges of this trial. Hank and I disagree with some of her rulings. Well, we've never had a trial where we haven't disagreed with some rulings of the judge. But given the unusual events that occurred at this trial, outbursts by our client, statements by witnesses, even an outburst by someone in the audience, you can go your entire career as a judge and never face that. Judge Casper not only was always super well prepared for the trial, always very courteous and professional with counsel, but her temperament was one that every lawyer can admire. She was an outstanding judge to handle this case, and we're glad she was assigned it.
If James Bulger knew that it was never about getting freed, what was it the trial about for him?
The trial for him, I'll let Mr. Brennan say.
I'm sorry, I didn't hear the question.
Jay Carney said the trial was never about him getting freed. He knew he was going to die behind the walls of a prison or on a gurney. So if it wasn't about getting freed, what was the trial for him?
Our objective in this trial when we started was transparency and to try to find the truth. And Jay Carney and I discussed strategy weekend after weekend, and we knew coming into the trial it was important. It was important for the jury. It was important for the community. It was important for the public to know how the federal government operated during that time and how they're operating today. So when we approached this case, it was important for us to get as much information to the public and to the jury as we could to demonstrate what happened, why it happened, and ultimately who is responsible. We mentioned that there's a ledger, accountability. Accountability doesn't come down to one person. Accountability is everybody who had a hand or a role and the carnage that lay behind what happened during that period of time. Jay Carney and I talked regularly. We felt the presence of families and victims and people left behind. And it was a unique opportunity that we could cross-examine witnesses, attack the untruths, and to be as bold as we could during this case to get answers for people that have deserved answers for decades. People who have been deprived of the answers about what happened to their loved ones and why it's happened. Answers to who is accountable and who's responsible. That's why we called members of the FBI that the government chose not to call. People we had never even spoken to before, to get them on the stand and try to find out answers. That's why when we cross-examined witnesses, we didn't shy away from areas. We wanted to know. We knew the community wanted to know, and we knew that many of the victims' families had to know. And we did our best. At many points, we were stopped over and over again. We were prevented from bringing out information that our members of the public, our citizens, are entitled to know. And so that's why we say today, really, for us is the first step. There's another chapter to be written. There's more accountability. And our government needs to answer the hard questions that have been raised by this case. There are answers that are needed by the families and the public that the families and the public need to keep pushing for. And so we've tried our best. And we'll keep trying the best we can. And now it's time for the public to try as well.
So Brennan, is there any message from your clients?
All you.
No. And speaking for myself, I will take one further question by someone who has not asked one yet. Officer, do you have a question, sir? You've had a question. Yes.
Did he have a comment about that?
No. All right, I'll give one other bonus question. Sorry, you've had your question. Has it been worth it? I've never said no to a judge when I've been asked to represent someone by court appointment. And I don't regret any of them in my entire career.
So you're ready for the appeal?
Ready for the appeal. Well, the lead issue on appeal will be the ruling that prevented him from presenting the immunity defense to a jury. Was that ruling correct? Look how different the trial would have been if that ruling had not been made. We would have had a number of very interesting witnesses called by the defense. All right, folks, let me offer my congratulations to you as well. I know it's been hot out here day after day. Some days it felt like a monsoon, but you did your job. And as a firm believer in the First Amendment, I thank each and every one of you for making the First Amendment a real thing for us in the Boston and community and elsewhere. You did a great job.
Thanks, folks.